Okay, Michael, how is that not a Fifth Amendment violation? The defendant could have gone into the police and told them it was a prop gun. How is that not a Fifth Amendment violation?
That's interesting. Interesting.
I didn't have time to post this because I was too busy taking.
Yeah, I'm so upset that he's done.
Yeah.
I was just getting into the rhythm
Yeah, you
there.
think they're going to go home? I think the jury's going to want to go home, celebrate Valentine's Day, and come
I
back
don't know. It's a
Tuesday.
tricky holiday.
Well,
It's
but
four
it's only eight
o'clock.
minutes.
Not
It's
even
four,
4 o'clock.
right? Yeah.
If they can get done by 6 and call it
I don't know, but if the
a
judge is going to
day,
let them deliberate, right? He said it was
that's
going to
always
be
a,
from,
that's always
you
a
know,
problem. There's like a lot of courthouses. They button up at 5, and
right,
staff's
right,
gone, bailiffs are gone, and they have to get approval to have people overtime.
right. And they have to
So
get approval of people overtime. Plus, he told the jury they'd be finished at 4.
yeah, well,
Yeah.
they're going to be
So
done. It's
and
4.
Lewin said, "Oh, don't worry, you'll get a chance to deliberate. It's going to take them that long to get the
Yeah,
evidence. It's going to take them half an hour to get the evidence
I
in."
just couldn't believe. Eventually the end of my notes just said retread, 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 because he just kept saying he
Throwing them
basically
on the
covered
floor.
everything that Paulie P covered.
Right. And
But
I'm actually throwing my notes on the floor. Okay.
but in the Lewin style, so of course it made it much more important. And they both made this interesting comment about self defense, right? And
Yeah.
about hey, they can't have it both ways. They can't say it was a prop gun and that it was self defense. Yeah, you can. It's
Yeah,
called
you can. Right.
alternatives. You're basically telling the jury it was a prop gun. But if for somehow you believe it was a real gun, then there's self defense here
Right.
justifying the use. But
Right.
it makes it sound like you jury members, you're just so stupid if
Yeah.
you fall for that.
Right. And then you and I are discussing this. Me especially, as you know, I was on it with on Twitter. The fact that he kept bringing up Rihanna and the baby, and I kept objecting to that. I said that, and the judge told him not to do it again. He said, "But Your Honor, but don't do it again."
Yeah,
Okay.
no Riri and the family.
And I don't
Yeah.
know how that's not a and the judge is wrong on the burden shifting. I can tell you right now because the prosecution did a lot of times. Why didn't they do this? Why didn't they do so? I see Joe objected at the very end there. That's burden shifting. There's no doubt. And if you count them up, there's a lot of burden shifting. But let me ask you this, because you're on this. How is the prosecution saying that we can't prove to you definitively this was a firearm,
Well,
not a motion for a judgment of acquittal?
I got you. I mean, to me that
The
was
first
just.
award
Hold on.
relates to
Oh, here we go.
the jury instruction on circumstantial evidence. It's jury instruction number 224. Jury instruction number 224 tells you everything you need to know about circumstantial evidence. There was some question about whether it was shown in its entirety. The entire jury instruction is in 224. Another thing I want to mention to you is I think it is very obvious that everyone at that table left it all out of the field. Everybody put out 150%. I think that's very evident. All right. I want to hopefully focus your duties by kind of summarizing something that both sides have mentioned to you. All right. The people have the burden to prove beyond a reasonable doubt that the gun was real. If the people have not proven beyond a reasonable doubt that Mr. Mayers used a real 9mm, then the verdict is not guilty. If you do find that that the gun was real, then you look at the 5 elements that are listed for assault with a semi-automatic pistol. That's jury instruction 875. You have to decide whether those elements, all 5 elements, have been proven beyond a reasonable doubt. Then also you can consider the jury instructions on self-defense and the defense of others. You have that jury instruction as well. So I'm hoping that this assists you in kind of focusing how how you deliberate. All right, I'm going to read the 2 final jury instructions. When I'm finished with this, I'm going to send you to where you're going to be deliberating.
Oh, he's going to let them
You won't be
deliberate, Michael.
deliberating in the jury deliberation room here for this court. You'll be deliberating in the deliberation room that is from my court, which is Department 115 on the 11th floor. So when I release you, I'd like you to go to the 11th floor and go to Department 115. Department 115, it's right there when you get off the elevators. And Alex will meet you up there. He'll escort you into the jury deliberation room. You can take all of your materials, you can set them down, and you can leave for the day. On Tuesday, you must be here by 9 a.m.
Not going to let them
Jury
deliberate.
deliberations start at 9 a.m. And when you show up on Tuesday, you're to gather outside the courtroom doors of Department 115 on the 11th floor. Did you want to say something?
Yes.
Same thing?
If it's not too much of a problem, can we start at 9:30? If possible, if everyone's okay.
There's the lady with the kid issue.
Yeah, I mean, it's an issue.
Is that what you all want?
And I said to you, I think
Yeah, all right, 9:30.
that he's going to let him go home for Valentine's Day and come back.
Yeah, I don't know if
When you go to
Valentine's Day
jury
is
room,
the deciding
first thing
factor.
you should do is choose a foreperson. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide the case for yourself, but only after you have discussed the evidence with the other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you. Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please treat one another courteously. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. As I told you at the beginning of the trial, do not talk about the case or about any of the people or any subject involved in it with anyone, including but not limited to your spouse or other family, or friends, spiritual leaders or advisors or therapists. You must discuss the case only in the jury room and only when all jurors are present. Do not discuss your deliberations with anyone. Do not communicate using social media during your deliberations. It is very important that you not use the internet in any way in connection with this case during your deliberations. During the trial, several items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room when you begin to deliberate. I made arrangements for a screen, a projection screen that could be brought into the jury deliberation that's actually bigger than that. So if you want to review the videos, you'll be able to do that. We're going to need a clean computer, though, that they can use. You've got to connect the computer to the projector, which is connected to the screen. Mark, our audio-visual guy, he can show you how to do that if necessary. If you need to communicate with me while you are deliberating, send a note through the bailiff signed by the foreperson or by one or more members of the jury. To have a complete record of this trial, it is important that you not communicate with me except by a written note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will answer any questions in writing or orally here in open court. Do not reveal to me or anyone else how the vote stands on the question of guilt or issues in this case unless I ask you to do so. Your verdict on each count and the special finding of the firearm allegation must be unanimous. This means that to return a verdict, all of you must agree to it. Do not reach a decision by the flip of a coin or by any other similar act. It is not my role to tell you what your verdict should be. Do not take anything I said or did during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. You must reach your verdict without any consideration of punishment. You'll be given verdict forms. As soon as all jurors have agreed on a verdict, the foreperson must date and sign the appropriate verdict forms and notify the bailiff. If you are able to reach a unanimous decision on only one of the charges,
The
fill
Karen
in
Reed
that
thing.
verdict form only and notify the bailiff. Return any unsigned verdict form to the alternate
Obviously,
jurors.
Mass doesn't have that.
The jury will soon be deliberating, but you are still alternate jurors, and you are bound by my earlier instructions about your conduct. Do not talk about the case or about any of the people or any subject involved in it with anyone, not even your family or friends, and not even with each other. Do not have any contact with the deliberating jurors. Do not decide how you would vote if you were deliberating. Do not form or express an opinion about the issues in this case unless you are substituted in for one of the deliberating jurors. Will the clerk please swear the bailiff?
Yes, Your Honor. Please raise your right hand. Thank you. You solemnly state that you take charge of the jury. You keep them together. You will not speak to them yourself, nor allow anyone else to speak to them on matters connected with this case, except by order of the court. When they have agreed on a verdict, you will return into court. Furthermore, if you take charge of the alternate jurors, keep them apart from the jury, whether delivering on a cause, until otherwise instructed by the court, so help you God.
All right, the case is now yours. Alex is going to meet you on the 11th floor in front of Department 115. He will escort the 12 of you into the jury deliberation room. You can put your materials down, and then you can leave for the day. Remember, 9 o'clock Tuesday, 9:30 Tuesday, please be outside the courtroom doors, not here, Department 115 on the 11th floor. For the four alternates, I'd like you also to go up to the 11th floor now, and what I'm going to want you to do is to give Deputy Bennett your contact numbers. I assume you all have cell phones? All right, I'd like you to give Deputy Bennett your cell phone numbers so we can reach you in case we need you. And if we do call you, we're going to need you quickly. So while the jury is deliberating, you can be in the hallway, you can be in the jury assembly room downstairs, you can walk around, you can be in the cafeteria, but you have to be ready, willing, and able to come to the courtroom if you're summoned. All right, you folks are going to be excused now. Take all of your materials. Council needs to remain. We have a couple of council.
Your Honor, what should the alternates do with our materials?
Yeah. You can leave those. We have chairs upstairs in Department 115. You can just find a spot and you can leave them there. Everybody take all of your transcripts, notes.
Okay, there's going to be some law in motion here, or something.
Well, I mean, there's going to be a motion for the judgment of acquittal. I think on the issue of the word deliberate, I mean, quite frankly, I think there was Fifth Amendment violations. I do believe there's burden shifting, but I don't think the judge wants to take anything away from the jury. And that's where we are. At some point, I mean, this is ridiculous. And this whole thing, while I appreciate everybody staying on with us for Valentine's Day, obviously the jury is going to go home tonight for Valentine's Day. They're bringing everything up to the 11th floor. They have to put it all down, and then they get to go home. But did you hear them saying transcripts? I guess that was transcripts of the calls.
Of the calls. There were which was great. They should have those, and it's good to have them.
But to take everything with them, all the notepads and everything else. So it's kind of interesting. Okay, here we go.
In the information, there are two aggravating factors that are listed. In the event that Mr. Mayers is found guilty, the aggravating factors that come into play. Obviously, if he's found not guilty, the aggravating factors have no relevance to anything. What I want to know is whether, if there is a conviction, how you want to deal with the two aggravating factors. What I mean is you want the jury to make a finding as to whether they're true or not, or you want to let the court, me, at some time in the future, make that decision. What about,
We'll wait.
all right, in the event that the aggravating factors become relevant, you have a right to have this jury determine whether or not the aggravating factors are true. And they have to make that finding beyond a reasonable doubt. Either the jury can do it, or I can do it. Whether the jury does it, or I do it, the standard of proof is proof beyond a reasonable doubt. Now, Mr. Tacopina has stated that I can make that decision rather than the jury having to make that decision. Do you understand that?
Absolutely.
Do you waive your right to have the jury make the decision and agree that I can make that decision in the near future, when it becomes necessary in the future?
I do, yeah.
Join?
Yes, sir.
All right, the next question is readback. If there is a readback, request for readback of testimony, what I would want to know is whether both sides are willing to waive their presence and agree that the court reporter can go into the jury deliberation room and provide the readback of testimony. However, both sides will know what that readback is before it's ever provided.
I agree. We're fine with that as long as we're in agreement with what's going to be read to them.
Any communication from the jury, whether it's a request for readback or a question, will be given to both sides before any response is given to the jury. If there is a request for readback, all of you will know what the request is and will hammer out what readback will be provided.
With that, then we have no problem with the court going back.
All right. Again, Mr. Mayor, you have a right to be present for the readback of testimony. What would happen is the readback of testimony would happen in open court. And you would be there, your lawyers would be there, the prosecutors would be there, and I would be there. In the alternative, you can waive your right to be present. So what would happen is if there is a request for readback of testimony, the testimony would be provided, but it would be the court reporter going into the jury deliberation room and providing the readback, the testimony that is requested. And you won't be in there, your attorney won't be in there, the prosecutors won't be there, and neither will I. You understand? You waive your right to be present? John?
Yes.
All right, the last thing is, I thought that 1 hour call would be appropriate, meaning that if the jury summons that they have reached a verdict, that the verdict would be read an hour after they have made that notice. Do you have any response? Do you think it needs to be more than that, less than that?
I mean, no, it should be fine. I mean, obviously, no, it should be fine.
Oh, that reminds me. Mr. Mayor's, well, under the circumstances, Mr. Mayor's needs to be here within 1 hour also.
Yeah.
All right. People, do you think 1 hour is sufficient?
That's fine. If we could, an hour and a half would be easier, but if the court wants an hour.
Well, no, I can make it,
90 minutes would help us. I'm guessing.
I'm fine with that. I don't care. That's fine. If you want to time, that's fine.
all right, we'll do 90 minutes, and if everybody can gather before that, okay? But it'll be 90 minutes from the time that we're notified that there is a verdict. What I said to the jury, that all of you left it all in the field, I mean that. You all put out 150%. So you did your clients proud. All right, anything else to take?
We do have one.
Just one thing. So during the PowerPoint presentation by the people, they played the video from 1616 Priest Del Mar, and I can't be certain of this, but it appears to us that the sound of the first shot was played earlier on the video they showed to the jury than the one that they presented in People's Exhibit 15. So just before we leave here today, if we can just look at the PowerPoint presentation to confirm that the video was the same video admitted as People's Exhibit 15 would be fine. If the shot was actually moved, if they modified that video in some way, we'll have to figure out some type of remedy, but I just wanted to clear that before we bring it today. If that's okay.
Nothing was modified in any way, Your Honor. We took the videos that were admitted and used them as valid. I do not believe that I need to sit down with counsel and go through. I think the court is certainly in its authority in ruling that that is an insignificant issue. The court has seen the evidence that's been presented, so I'll leave it up to the court.
The jury has the exhibits. No, I'm going to deny that request.
Your Honor, it was evidence on it's not an insignificant issue as to whether or not the shot occurred before Relly went to Hills. It's a significant issue in this case. In fact, the people now aren't letting us look at it, particularly after they tried to present an exhibit of knuckles that weren't in evidence. It's disconcerting. The court's not going to let us look at it. It is what it is.
All right. I think that showing the exhibit of Relly's knuckles, I don't think that was intentional. It was an oversight. Mr. Lewin said it was an oversight. It was a mistake. We're all human beings. We make mistakes. The jury has the exhibits. The exhibits are what matters in this case, not the PowerPoint presentation. Where's Mr. Deputy?
There he is.
Oh, there you go. That's what. Did you want to bring anything up?
No.
Mr. Wilbur, anything?
No,
Mr. Lewin?
no, just a reminder on the
Yeah, I would have forgotten that. That's why. Thank you. All right, well, that's the record.
That's a wrap.
Well, it's one big kumbaya moment there. Everybody's applauding everybody's work. What do you think about the 90 minutes for Lewin? This guy's the closest guy.
He's always office is right there. I
right
mean,
there.
he's right there. His office is right there. I mean, it's he wants 90 minutes. I mean, can you imagine the jury sitting in there? They have a verdict. Knock, knock, knock.
Mm-hmm. Yep, and then cooling their heels for another freaking 90 minutes.
90 minutes. That's ridiculous. Quite frankly, I'm surprised it's an hour unless you have quote victims. Are they planning to bring Relly into the courtroom as a victim? Usually,
Yeah, could be.
Could be. They could be.
And it is LA, so but still, for the guy who's the closest to ask for the extra 30 minutes is a joke.
Yeah, I mean, I think that's an absolute ridiculous because they're going to be standing in the hall. You're in the hallway anyhow. You're waiting around. They just told the alternates to wait around, right?
Oh my
in the courthouse, right?
Yeah.
So they got to run around the court. They got to there's no place for them to
there's
go.
a cafeteria. There's
Yeah, but there's really no place for them to lie down if they want to relax. I mean, they're going to be sitting on hard pews. I mean, and then there's a 90 minutes,
Yeah, I don't know why they don't see. The theory is, okay, we need an alternate. Go pluck one out of the hallway or the cafeteria so we can save the travel time they might have to use to get here.
But now
I don't think that's fair to the alternates. They already feel like they're getting screwed because hey, we've sat through this. We don't get to do a damn thing. They should just say, get here as quickly as you can.
That's right, exactly. I mean, get here. You're in LA County. Get here as quickly as you can, and then there you go. I mean, plus, Lewin left the whole day. He knew that he was going to 4 o'clock. He knew. And now you and I said that. I said that this jury is going to go home. This judge is going to go home. They're going to celebrate their Valentine's Day there. Right, and then they're going to come back Tuesday to.
I like your romantic streak there. I'm not so sure that Valentine's Day was a motivator. I think it was just like it's Friday, it's the end of the day. Let's just we're not going to resolve anything in the next hour if 5 is court closing time. Yeah, let's just call it. But I like your romantic streak.
Well, it's.
How was your Valentine's dinner?
I have spent it with all of you, and I really thank all of you for spending it with us. How about this? They waive the right, if there's a readback, to go into the jury room and just have the court reporter do the readback. You normally like to bring them out. You'd like to see what the reaction is to the readback, what they're looking for and all. But they waived that. They said, no, the court reporter, whose name I think it was Kathy, can go in there. We waive the right to be there. You know.
Yeah, I mean, they'll discuss it with the court ahead of time. They just
Yeah.
won't do any answer for the jury. I'm sorry, they won't do the back and forth with the jury in open court. Sometimes they bring the jury in.
Right. They
Right?
bring the jury in.
And
Usually they bring the jury
they
in.
discuss
Right.
it and say, the court would say, here's your question. I'm read that into the record.
Right.
And here's our official answer.
Right, right, but this you had to waive your right because he had a right, I guess, to watch whether it goes in the jury room or out, and they waived the right to. What do you think about that?
I don't know. I think it's a little unusual, but practical. In this case, where there is a little bit of travel issue, and if you're popping back in, and how long would they have to wait? Would it be another hour and a half to
They have
come
to go
in,
downstairs,
reconvene?
right? They
so
they
that
had to go
could read
downstairs, right?
Yeah.
Yeah.
So
And,
maybe it's a practical decision.
Yeah, so maybe, and it also shows that he trusts them. He trusts the court reporter, obviously, and sometimes maybe they'll feel better, but obviously they may not know they're not allowed to ask the court reporter a question. There's going to be a bailiff's officer in there, right? There's going to be the court officer, the court clerk will have to go
And
in
they'll
there.
have a transcript, and
they'll have a transcript of it, and they'll know. The attorneys will know in advance. I mean, what is
yes,
being,
they'll know what's going in there. All the transcript will do is confirm that what they agreed to is what the jury was told.
What the jury was told. I don't know, Michael.
Yeah,
I got a text. I got a text from somebody who I trust, who follows all these cases, and says, "And you guys tell me if you right." The text was, "What's going on? Why are people on Twitter saying ASAP is going to jail?" I don't see people saying that except for like maybe one person, but.
Yeah, I mean, maybe we're in an echo chamber here. Maybe only people who think that he is getting kind of a raw deal come here, and everybody else who thinks he's guilty is elsewhere. I don't think that's true. I think we have some reasonable people here who are weighing the evidence that they've seen.
Right.
But yeah, I mean, who knows? I had another couple of notes. Do I have time to share those, or should we just get the heck out of here?
Let's share them, and then we'll be out of here by probably 7:30. And yes, we'll be on an hour call Tuesday. Tuesday. Let's see, what time is, so they'll be finished by 7:00 Tuesday anyhow, even with the verdict. So we'll be on an hour call Wednesday. Michael will be here covering the hour call because I'll be in New Jersey all day.
Wednesday this is going to be a distant memory.
I think so too. And by the way, one other thing, did you see, and I pointed, the judge said, if you have a verdict on one but you can't decide another, tell me.
Let me ask you this. Instruction 224, circumstantial evidence. This was obviously asked for, I'm guessing, by Joe, because we heard Lewin rely so heavily on, this is not a circumstantial evidence case. This is not a circumstantial evidence. It's direct evidence. And he talks about witnesses. True, direct evidence.
Right.
And he talked about some of the other elements, saying those are all direct evidence, all direct evidence. I have a feeling that Tacopina just wanted the jury to be reminded that there are two kinds of evidence. Don't necessarily take Lewin's pronouncement that there is no circumstantial evidence in this case as fact.
I agree with you. I think you're absolutely right. I think you're absolutely right.
Then one other point. Excuse me. One other point.
No.
There's a point at which, in his closing, his rebuttal, Lewin threw up the picture. Lewin threw up the picture of the knuckles, and it immediately I thought, man, that's actually a brighter, clearer picture than we've seen, right?
Right.
And Joe Tacopina objected because that is not the one that's in evidence. And Lewin admitted, oh, you're right. And he found the one that's in evidence, which is not as good a picture. So I thought it was kind of a drop the ball on the prosecution for not having both of them in, or the better one in.
Well, maybe the better they couldn't. They probably were doing their own, upgrading of the picture to try to see pixels and all, and they couldn't validate.
Yeah, it's hard to tell.
But in California, normally the clerk has the evidence that's been marked.
Yes.
You have to go get it, even when you do your closing. You go get it. So I don't understand how that mistake can be made. But the judge said
I think he just took it from maybe his own pile, not from the pile of evidence.
Right.
And I don't say he was doing anything
the judge
improper,
I know,
but Joe caught it, and it just surprised me they didn't have that in evidence. Get both, get the best ones you can.
Yeah, I think it was highlighted. So that Bev Mills asked, "Would the judge said they'd be sequestered?" No, he did not.
No,
California,
not. That would be crazy.
Yeah, and it costs some money, and it's hard to get juries sequestered these days in California. because it costs so much money to sequester a jury. And you know what? Sure. I mean, you know, do you think, you know, we all think that jurors kind of know what's happening, by the way, but as lawyers, but you know, you never know.
Okay, here's something that came up that was surprising to me, and based on the charges as they exist. This is assault with a semi-automatic weapon, right?
Right.
The judge said, and this was interesting, the aggravating factors, should there be a conviction, they can be decided by the jury, they can be decided by the court. What do you want? And it was decided it's going to be the court. But I started thinking, okay, normally if you had assault with a deadly weapon, right, that could be a knife, that could be, if you're a boxer, it could be your
Right.
hands registered as
Right.
lethal weapons.
Right.
And then there might be an enhancement for a gun, right?
Right.
Or an
Firearm, right.
aggravating factor.
Right.
The aggravating factors, I guess, could be priors,
Right.
you know, because this is a charge that in and of itself includes the gun.
The gun. Right.
So that's not an enhancement or an aggravating factor. So what else do you think would be the aggravating factors?
I know there's two of them. So that's what I was thinking too. And I went looking quickly because I see on the indictment and I don't see it. So there has to be.
So I'll have to look at that, look at the code and see what the normal statutory aggravating factors are. But I'm guessing it's going to be priors. It's going to be a number of those
type of things, right? Yeah. You know, I don't know. It couldn't be two victims because there's only one victim, unless the state was charging that there was a danger to other people around. Which he said, Lewin did say that he put you and I. He said you put you and I in danger is what he said.
Twice they talked about how somebody else could have been shot. Yeah, so that could be. I don't have to look at that.
So
it's
we'll
not
have to
age.
Find that. Yeah,
it's not age of the victim. It's not age of the defendant.
Right. You and I have to find out that over the weekend. The other thing is, you know, you fought for years. Defense attorneys fought for years to have aggravating factors decided by a jury beyond a reasonable doubt. And interestingly enough, they said no, we want the judge. So
I wonder if that's as much a function of confidence in the defense case, you know,
and
they think it's never going to get to it, and yeah, exactly, yeah. And also think about it this way: if a jury, and they certainly could, finds guilt, would you want to trust them with finding aggravated factors?
No.
In this case, I wouldn't either.
No, absolutely not. Absolutely not. But it's got to be scary. This is going to be a weekend where, you know, no one's going to sleep. Let's face it. No one's going to sleep. It's a tough week, except you and I, because we're exhausted.
I'll be fine. Yeah, I'll be fine. And then we'll deserve a little time off, as Missy will.
As Missy will. Thank
next week we'll work that out. Yeah. And the Monday, we'll do something Monday. I don't know if we're going to have a guest or if we'll have a pre-recorded show. We'll
I think it may be that pre-recorded show.
Or you want to do you want to run some of the arguments?
I think we should just run the arguments in trial, let everyone catch up, because a lot of people have not caught up. You know, they're working all week, and Monday's a holiday for many people. But run the arguments in trial and hold the pre-recorded show. I mean, if it's not too old by the time we run it.
I can't imagine what could possibly happen. You know, if we did just the last day plus some of the arguments.
Yeah.
Definitely not all of them.
Yeah,
okay.
Definitely not all of them.
We'll figure that out. But okay, well.
Thank you all. Thank you all.
Thanks to everybody. Have a great Valentine's Day. What remains of it?
What remains of it? And again, thank you for spending it with us at Justice Served TV.
We appreciate that. Thank you, Missy. And I'm Michael Bryant. See you next time. In the meantime, try to do the right thing.
And I'm Linda Kenny Bodden, and together we are Justice Served TV. And if you like us, please hit that like button, subscribe, share, and also hit the notify button. And we will see you Monday.